What's up, court nerds? Time to get served. It's your boy Phil. The first live. What's up, court nerds? The 2K Express is coming. What are we doing? What's up, guys? How we doing? Meteoric rise. First 2K live stream, as I promised. And the gods of the court Zoom has rained upon us tonight. When you see the clips I have accumulated today, I thank you. Let's do this. Let's have fun. If I have technical difficulties, it's my first live. Please be patient with me. First up, we have the ultimate crybaby. You saw the preview of it. Let's roll.
Recognizance to an out of custody arraignment date. We'll hopefully see her then.
All right. The last matter we have that was physically transported is Mr. Morris. That's cause number 34258. This is on for pretrial. Underlying allegation here is a driving while license revoked in the second degree charge. I had an opportunity to speak with Mr. Morris. I based on our conversation, I do have some concerns about his ability to move forward today in regards to his competency. I think at this point, I don't have any other options other than to ask the court for an order for an evaluation. We did prepare one and send a proposed copy to the court.
All right. I'm sorry, I'm updating. Oh, there it is. Okay. All right. City's position, I assume, is no objection.
That's correct.
And is this for an in custody evaluation?
It is.
I believe that's the
All
city's request, Turner.
All right. I will sign. Mr. Morris, good morning.
Morning.
Based on the representations from the attorneys, sounds like we need to have some experts make sure that you're able to proceed with your matters with full understanding. So I'm going to sign the order to request an evaluation by Western State Hospital. They should come to the jail to do that. And hopefully we'll have a better idea of how we're going to proceed next time I see you. All right. So I'm going to maintain bail and we'll set this matter over. Let's set a hearing date. Do we have?
Who's maintaining bail mean?
Means that the bail is going to stay at the amount that it is currently set.
Okay, and then do I get to leave then?
Not unless you post bail.
How much is bail? Because I already posted bail, and when I tried to get the warrant quashed, the courts wouldn't let me.
Here we go.
I went to the I called them and I had a court date scheduled, and I went to the court date and I talked to them, and then they somebody there with COVID said they had COVID there, and then they told me that I could leave and reschedule again. And when I left, and then the cops came and got me. And now I'm just trying to, I don't want to be in jail anymore. I don't want to be forced to be in jail, and I want to do what I'm supposed to do the right way, but they're not letting me.
All right. Well, bail, I believe, is currently set.
There's too many people against me, and it's only me helping me.
Well, Mr. Morris, actually, Ms. Pimentel is here to help you as well, and bail is set in the amount of $2,000. So I'm maintaining bail in that amount, and we'll set this matter for a hearing.
But I bailed out with Aladdin. But I bailed out with Aladdin.
You did, and then you didn't show up at the next court hearing.
But I tried. I went to the next one, and then I tried in the courts, and then the guy with he was Asian, and he moved the chairs a different way in certain ways, and moved the chairs, and then it was like he was telling me to leave because somebody had COVID.
I don't know what you're referring to, Mr. Morris. So what I'm going to do
when Leslie brought me to court in Bothell, she dropped me off there, and I had my scooter.
Okay, Mr. Morris, I need you to be quiet for a little bit now.
No, I don't want to stay in jail anymore. I don't want to stay in jail anymore. I don't want to be in jail anymore.
I understand, Mr. Morris. So
You
what I'm
don't
going to do,
understand
Madam,
because you don't go to jail. You're a judge. You don't go to jail. That's not fair. That's not okay. He's a cop. He doesn't go to jail. He doesn't go to jail. He doesn't know what it's like because he doesn't go to jail. Why don't you go to jail and tell me you know what it's like after you go to jail?
all right. So we'll set this matter, Madam Clerk. What date do we have? About 2 weeks out to check and see if the evaluation has taken place.
February 28th.
Okay, we'll set this matter to February 28th at 9:30 in the morning. Mr. Morris, if you do post bail, you will need to appear by Zoom. If you can't do that, you need to come to the court. Okay, so we'll see you on February 28th at 9:30 in the
Come on.
morning. Okay. And I am signing that order.
I'm going home.
Your
Bravo.
Honor, those were all the matters that were transported. Again, if we go back to the calendar.
0.520C2.
All these clips are from today. All these clips I got, these are literally from today. It was like one after another. It was like they knew I was going live and they said, we're going to give time as many clips as we possibly can. Just hit his feed just so he could go as live as possible, as long as he possibly can. So here we go.
14 in count 1, being 17 years of age or older, did engage in sexual contact with a person under 13 years of age, contrary to Michigan Compiled Law 750.520C1A and Michigan Compiled Law 750.520C2B. This is a felony with a maximum of 15 years in prison, up to lifetime electronic monitoring upon parole from prison. Count 2 is alleged being 17 years of age or older, did engage in sexual contact with a person under 13 years of age, contrary to Michigan Compiled Law 750.520C1A and Michigan Compiled Law 750.520C2B. This also is a felony which carries a maximum of 15 years in prison and lifetime electronic monitoring upon parole from prison. Count 3 is alleged being 17 years of age or older, did engage in sexual contact with a person under 13 years of age, contrary to Michigan Compiled Law 750.520C1A and Michigan Compiled Law 750.520C2B. This also is a felony which carries a maximum of 15 years in prison and lifetime electronic monitoring. In count 4, it is alleged that you did willfully violate the Sex Offenders Registry Act by failing to update your address within 7 days, contrary to Michigan Compiled Law 28.72918. This is a felony which carries a maximum of 4 years in prison and or $2,000 fine. Did you hear and understand all the charges that I said?
I got a question though. Is those from the last time you just seen me, or you're reading them all together?
This is a new case. This is a new charges. These are different charges.
Why am I being charged with that last one twice?
At this moment in time, I can't say. I don't know. All I can tell you is this is what is being charged in this case.
Okay.
Okay. And sir, I am going to order that you participate in a DNA sample. So you do need to comply with that. And if you have already, that is fine. It's merely, you do need to comply with that. If you haven't already.
I ain't doing nothing else.
All right.
Where's my lawyer at? Where's my lawyer at? I am my lawyer.
Well, these are new charges, so I'm asking, do you want an attorney to be appointed?
Yeah, where's the other lawyer at? This is supposed
Okay, so you do, on these new charges, you want an attorney also, correct?
Yeah, but what I'm saying is, I wasn't supposed to be here for these new charges. I was supposed to be here at 9 o'clock this morning for the other charges.
Yeah, my understanding, he's in a different courtroom. We will We will have him here in hopefully a little bit. I am going to place bond conditions on you. So you are to have no contact of any nature with the victim, Natalie Lynn Saldivar. No verbal, written, or physical, directly or through another person other than law enforcement. You're not to be at the victim's residence for any reason. Hold on, sir. Let me tell you what the bond conditions are, okay? You're not to be at the victim's residence for any reason without law enforcement present, not to possess any keys to the victim's residence, not to have any type of weapons in your possession, and no contact with anyone 18 years or older or younger.
Older or younger.
No, not to have anybody, not to have contact with anyone 18, hold on,
I got 9
not to
kids.
have sir, no contact with anyone 18 years old or younger.
Did you not? I got 9 kids under 18, man, so I can't house none of my kids.
At this moment in time, no.
Smack yourself.
All right, I am going to order a court-appointed attorney.
Y'all believe anything, don't y'all?
What's that?
Y'all believe anything, don't y'all?
It's not a matter of believing at this time. I do not know if this is accurate or not.
How do you?
All I have is the allegation, sir.
Go ahead, man.
So how you know this ain't all the setup so I can see you guys? Huh?
Well, at this moment in time, sir,
That people say. So
Sir?
when this lawsuit comes,
hold on.
you can cut it off, I don't care. It don't make me no difference, I'll sit here. But I'm just like I said, how do you know this ain't a scam to sue you guys? You guys
Sir,
know what's going on, you guys believe anything?
sir, at this moment in time, sir, at this moment in time, I'm not saying whether you're guilty or innocent. I'm telling you what the charges are, all right?
Dude, this is 2023 and they're coming with some stuff in 2014? Come on, man.
That is what,
For
I'm
8
also,
years,
sir,
9 years.
sir, at this moment in time, I'm also going to be placing a bond conditions on you. What that means is you have, basically on these charges, it's a new bond. In count 1, criminal sexual conduct, second
Come on,
degree.
guys. What do you think? Let me know in the comment. This guy, POS, or is the court lying? Come on.
That'll be a $30,000 bond. Count 2, criminal sexual conduct, second degree. That'll also be a $30,000 bond. Count 3, criminal sexual conduct, second degree. That will also be a $30,000 bond. And count 4, sex offender failure to comply with Registration Act. That'll be a $3,000 bond.
Okay, what the fuck that mean?
Ooh, dropping F-bombs.
And as stated, I am appointing a court-appointed attorney in this case. At this moment, that's all in this case. However, we still have, we still have a, sir,
Bond.
You heard what I said.
we still have, sir, do you like interrupting?
Yep.
Yup.
Well, I advise you not to.
Oh, well, I'm in jail anyway. What you gonna do?
Would you like me to place it consecutive? Because I can place consecutive, and then whenever you get out, you can spend some extra time.
Whatever.
At this moment in time, we're waiting for your attorney. As soon as he's here,
All right, here we go. A little lighthearted now. Just watch this. I call this one The Graduate.
Around the 16 to 20 over. What would you like to do?
I would like to go with the first one, the one that says impeding, no points.
Okay, so I
admit to the,
speeding. Okay, so on SP 1421245, January 9th, 2023, ma'am, were you driving a 2009 Saturn in the city of Detroit?
yes, sir.
You were pulled over by a Detroit police officer at some point that day, ma'am?
Yes, sir.
And prior to being pulled over, you were speeding 16 to 20 over the posted speed.
Yes, sir.
Thank you. The court satisfied will amend that to impeding traffic. That's a no point offense, and that fines and costs carry $175. How how much time do you need to pay those fines and costs, ma'am?
I can have it next week.
No
I'll give
cap.
you 30 days. That sounds
Guess
like
she
enough
threw it.
time. Just pay it sometime in the next 30 days, okay?
Thank you
There
so
it is
much.
again. Guys, this is what I'm going to do. I'm going to do from now on, I'm going to have a perfect balance. I have half of my subscribers that love when I interrupt and love my infectious laugh. And then I have another half that love my videos and love my content but think I'm obnoxious. So I'm going to find a happy medium. Until I find a happy medium, I'm just going to keep doing these hysterical videos. And how can you not laugh? I almost fell out of my chair when this woman, so serious, does she not know that's on her head? The judge doesn't even make a comment. Could you imagine? Oh my God. Could you imagine if that was Judge Bryant? We would have got like a snarky remark from Middleton or something from Bryant would have been,
Your Honor. I really appreciate that today.
Yes, ma'am. You're welcome. Absolutely. Do you have any questions?
No, only question I have is, will I receive something in the mail via email?
Are you on the Promenade Street address still?
No, I'm at 232.
Wait, Miss Karen, you're live on YouTube to the world, so I don't want to give out your full address unless you want to. If not, I can.
She's live on full display for the world. Don't want to give out that phone number, but don't tell her to take that graduate cap off of her head so all the court shows could replay it for months to come.
I'm on Beechwood.
Okay, so that's not the address we have. So take down this phone number, Miss Karen. As soon as we finish, you can call right into my courtroom, and Miss Tate will answer the phone and she'll update your address in our system, and we'll send you out paperwork to wherever address you tell us. Okay?
Okay. What's the number?
It's 313-965-8774.
Thank you, Your Honor.
You're welcome. Anything else, ma'am?
No, sir. Thank you. Thank you, officer.
Throw it.
You're quite welcome. You're quite welcome.
All right, here we go. Let's go another lighthearted moment here too. I caught this one. I almost had a heart attack on this one. So I think this one was older. It just popped up in my stream for some reason, but I think it's hysterical.
Right. Yeah, that's good.
All right, sorry guys.
Well, get where you want.
Here,
So he's trying to get the right zoom angle.
Okay, I want to be right about here. Okay, you're getting closer.
So touchy, you don't understand.
I'm in a Woody Allen movie.
Is that okay, right there?
Not quite. Go back a little bit.
What?
All right, yeah, that's good. Over here,
Well, get where.
Come on. All right, here we go. And then right after that, I caught another judge talking about his hairdo. Oh, it was fantastic today.
It looks like there's someone skipping there. When you move around, you see it?
I think they need to check this mic. Like a cord that I'm bumping into or something. This footrest. The feed sound different, doesn't it? When we're listening to it, these people sound different today. Like clearer to me. So I thought maybe they had worked on it. I think there's something with this mic, but they don't believe me. If it ever finds out that it's this mic, I'll be like, you guys owe me lunch because I've been telling you it's this mic. Because I don't know why it would break up on the FTR.
Right.
If it's, because that means if my mic's working fine, it shouldn't be breaking up on my recording equipment.
I haven't done a transfer in a while, so I don't know.
That hopefully no one orders one because it's probably not going to be fun. You may have someone order that. Oh well, that one. Not to name that case. They did order one already on that one that I just issued an opinion on, didn't they? In the last motion.
Which one?
The one that's up for de novo today. Yeah. That's how it goes.
He burped.
I always have this little piece of hair sticking up right in the back.
It looks like there's still a little stick in there. I don't know why.
All right, I think, and then
I'm sorry.
All right, and then I caught. Okay,
Yep.
so right here, then it jumped. We got Middleton. So this was Middleton's first case, and this guy is hysterical. It's about electric scooters, and Middleton's given us traffic laws about electric scooters. I mean, it doesn't get any better than this. It absolutely doesn't get any better than this. Here we go.
Good morning. Are you Ryan Featherstone?
Yes, I am.
All right, this is Judge Middleton. I'm here at the courthouse. We did this a little early today. Usually we don't do them until the afternoon. But I saw when I logged in this morning that you'd gotten arrested over the weekend. This is two cases in the matter of people's Ryan James Featherstone, file 221407 and 1507-1508. The public defender, Jeanette Jackson, is here with us. I asked her to stick around for this. You got a ticket on July 29th for driving without a valid license and having an unregistered vehicle. Those are both misdemeanors. This ticket was issued on Monroe Street at Chicago Road in the city of Sturgis.
It was a bicycle. He pulled me over on a bicycle, sir.
Yeah, it says mini motorized chopper.
Yes.
Ryan has been stopped many times in Sturgis in reference to motorbikes on the road is not valid.
I just put this bike together. He didn't even give me a warning. He didn't even give me 10 days to get it legal. He didn't give me nothing. He didn't give me the option or anything. He just took it from me.
All right, well, your problem is you didn't show up.
I don't have a vehicle. I'm sorry. I do now. I have transportation now. I didn't have transportation at the time to get here. And it was the day.
Can we just note that he is probably one of the sexiest and toughest, roughest guys in Sturgis with that cut off Deadpool shirt from Target? I mean, come on.
You just don't come.
Well, no. I mean,
Stop. Let me talk, and then I'll give you a chance.
Is that what my mic sounded like on my first couple of videos? And everybody said you blew my eardrums out because I had the mic volume to like 7.
I'm trying to decide whether to leave you in jail or let you out. So my suggestion is you be polite and respectful.
I am. I apologize.
Be in jail for about 10 days till we have a pretrial. You got these 2 tickets, no operator's license, and operating a vehicle on a roadway. It was set for an arraignment.
Oh, baddie.
And you didn't show up. So
yeah, because it was below freezing and it was snowing outside.
Well, this was back in the summer. You got arrested in December on the warrant. Apparently they submitted it for a warrant. You got arraigned at the jail. You posted a bond, a PR bond. They let you out of jail and they set a pretrial conference. You didn't come for the pretrial conference. So I did an order to show cause you to come in here.
I tried to make it, sir. I tried my damnedest to make it. It was below freezing. It was snowing outside the day I had court. I was just not able to make it. And I even called up here and then she said, well, I'm sorry, you have to come here regardless. And I tried to, and I couldn't make it.
How did you get arrested this weekend?
Oh, I was bringing clothes, or I was bringing food back from the store for my mom because I'm taking care of my mom.
All right. Did you?
And he pulled me over, riding my bicycle.
All right. You were on a regular bicycle?
Yeah. I mean, it had the 2-stroke motor on it. It's underneath 49 cc's. I don't need a license to drive it in the state of Michigan.
Well, that's a dispute between you and the prosecutor. So were you on the motorcycle, this bike again when you got arrested last night?
No, they still have my chopper in the pound.
They still got my bicycle in the pound, which it's a regular bicycle with a fucking
Okay.
2-stroke motor on it. Or I'm pardon my French, a 2-stroke motor on it.
All right, how did you get arrested last night?
Last night I was on my bicycle. He seen me carrying a trailer full of food, and he pulled me over.
All right, so you're on your bike. All right, now, are you still at North Prospect Street?
Yep. Still taking care of my mom.
All right, here are my options. I can leave you in jail in lieu of your bond until I get back from a trip and they finish working on my courtroom. Or I can let you out with the understanding that you'll show up this time.
Yes.
And you can meet with the city attorney and discuss this. I'll give you bus passes if you need them.
I would appreciate the bus passes more than anything, because my bicycle, my legs don't, and my condition, my accident condition I was in, it doesn't really go good with me walking.
All right, well, I'm going to I'm going to show you plead not guilty. I gave you 2 chances to be here. One was the pretrial. You didn't show up. Rather than issue a bench warrant then, I did an order to show cause, and you didn't show up for that. That's when I issued the warrant.
Right.
So I'm going to show you pleading not guilty. I'll set a pretrial with Sturgis City Attorney for March 1st, 2023. I'm going to find you're in contempt for failing to appear.
I'm sorry for that, sir. It's just been really hard out here lately.
Yeah, I understand.
You feel for him. I definitely feel for him.
Struggling ain't the word for it.
If we could get you in here, we could get this resolved. 1 day credit, 1 day.
All right.
You know Middleton's gonna cut him a break.
7 OT and no fine. Today's the 13th. All right, let's set the bonds.
Yes, it is.
That'll be at 8:30.
I appreciate you giving me another PR bond and another chance. I really appreciate that.
All right, well, you're probably gonna lose this bike because the impound is probably gonna exceed.
Oh, they already tried getting my bike back. They won't give it back to me. The cops even told me that I could get that they would release a paper saying I can get it back, and they won't even give it back to me. They said it's gone already. Somebody done stole my bike.
Maybe.
So I don't know what I'm gonna do.
I don't know anything about that. Now, when you get out of jail here in a half an hour, are you gonna have a ride back to Sturgis?
No, I'm gonna call my mom and have her husband come get me.
All right, then you come get. All right, if you need bus passes, have him come up here to the courthouse.
Okay.
I'll give you some bus passes to get here on the 1st of March. All right.
I'll do that instead. I'll go up to the courthouse after I leave here.
All right, credit 1 day. $250 PR bond per file. And I'm letting you out on your representation that you'll be here.
Yes.
At 8:30 on March 1st for a pretrial.
Yes, because there ain't gonna be no more snow, so I'm pretty sure I'll be all right.
All right. All right. I'll see you on March 1st.
Thank you.
All right, you're good to go.
All right. So now let's go to.
You let me out,
We got
Al.
another Middleton one from today too, but I'm gonna hop over to.
always
I'm gonna
an
hop over to
excuse
somebody
with
else.
Motorized
It's Judge
bicycles,
Rossi. I love Judge Rossi. I
mopeds,
don't know if you guys ever watched Judge Rossi before. He's got a personality on him, man. And this guy just doesn't care. He's just got like a no care attitude. I just found it so funny. These clips are all from today. I think I have one from the past that I found past clip, but all of these were from today. All of them you've seen so far on the live were from today.
21-06743PH. This hearing is being recorded on Zoom and live streamed on YouTube.
And Mr. Camp, I am arraigning you today on a bench warrant that I issued because you failed to respond or failed to show up for an order to show cause hearing on this personal protective order that I set back on, it looks like, well, December 29 or November 29th and December 15th. And that's when I issued the warrant. Why weren't you in court when you were supposed to be? You're muted, Mr. Camp.
I never got anything. And you said December, you said December and what?
Yeah, there were two in November. My notes here say November 15th, you didn't appear, but you called into my chamber saying you forgot the time. We reset.
Yeah, I got the time mixed up. And then I never got nothing in the mail about it again.
Well, you might not get something in the mail if we just tell you it was reset for a certain time and date, then you just got to show up. And this says, okay, well, it said we gave you 11/29, and then we probably would have mailed out the one on 12/15 if you didn't show up. Then what address are you staying at, Mr. Camp?
911 9th Street.
Okay, is that the same one we got on file for you?
It should be. I gave it to him today at the jail. Yeah.
Well, unfortunately, all these systems don't talk to each other about as efficiently as they ought to. So sometimes you have to give that address out a bunch of times. The only way to make sure it gets into a court file is to give it to the court clerk. So we will record that as your new address. And we've already set a new order to show cause hearing. It's going to occur on February 24th. At 2 p.m. and it's going to be on Zoom, just like this hearing, yes.
It's February 24th.
Yep, 24th, 2 p.m. on this same Zoom link.
All right.
And you do know that, well, that'll be the order to show cause. That's when I'll arraign you. That's not actually the hearing. What I'll do there is I'll swear you in and advise you of the potential penalty and that you have a right to a lawyer with the other party present. And then, appoint a lawyer for it if you can't afford one. So similar to, what a show cause looks like in misdemeanor court. So.
This is, I'm gonna be honest, man. This lady just completely lied to get a PPO, and she's lying about me violating. Like I don't even know this lady.
Good news is you get the chance to prove that. I'll do an evidentiary hearing ultimately, and you can prove that with the assistance of a lawyer. And if I believe you, then you won't be in any trouble about it. But in the meantime, the PPO, as far as I know anyways, remains in place. So
I thought that PPO was been expired. This is over almost 2 years. I don't even know this woman. I don't be over. This made me move from the house I was living in. I don't know this woman. And then just the other day when I got arrested, she was driving. This woman is harassing me literally.
She's the one following you around. Eh? But what's the connection between you and her, if any?
I don't have any. She's my old neighbor. That's it. And when she started all this BS, I moved. I don't know this woman. I have videos of her harassing me constantly. Like, this is ridiculous.
Well, I'll give you the chance to say your piece, but make sure you show up for your court date so I don't have to issue another bench warrant, or that'll get even crazier because then you get picked up and put in jail for a day over it all as well. So to avoid that, just show up on the 24th and I'll advise you of your rights then. You can enter a guilty or not. I expect you'll enter a not guilty plea, and then we'll go from there. I'll set an evidentiary hearing.
All right.
Nice to meet you, Mr. Camp, and see you on the 24th.
Nice to meet you as well. I appreciate it.
Pants on fire.
Can you stay on just?
All right, here we go. So, I love, if you've been following me, I've only been on for not even 2 weeks, but if you've been following me from the beginning, I love Magistrate Judge Gardner. He's my boy. I had to pull a clip from him. He has gold. He is fantastic. He shows his emotions on his face. Let's roll.
Sure, this is right. Hold on one second, Mr. Stewart.
So,
Hi, Deidre. Always leaving good comments for me. Pay attention to this case, guys. I'll be quiet.
Okay. Mr. Stewart, you're charged with theft by receiving stolen property being a firearm. I'm going to deny bond on that charge at this stage. Improper lane change, I'm going to set a bond at $500. Possession of marijuana less than an ounce, I'm going to set a bond at $1,500. And possession of suspected MDMA, I'm going to deny bond. You're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. I'm going to also set a bond hearing date for November 11th at 8:30 in the morning. It appears you're going to hire your own lawyer.
yes, I'm thinking about hiring my own lawyer.
Okay.
Because
You don't have to explain anything to me. I'm just asking because
I want to explain, but I just want to explain the right way and don't be out of line when I explain.
Well, Mr. Stewart, you have the absolute right to represent yourself, to hire your own lawyer, or to accept appointed lawyer, and you don't have to explain yourself to anybody.
Yeah, I wanted to explain to you because I just got out of jail on the 18th of these charges. All the drugs that I'm getting charged with today is the same drugs from when I got caught. On the 18th was already in the vehicle in the bag where they got the other drugs from. They did take all the drugs out the bag. When I got the car at the impound, no, I did not search the car to see if all these things was in the car required to the first time I got arrested. I just got my car at the impound the day before yesterday.
Okay, hold on.
I just got out on the 18th. I moved in my apartment on the 19th. I got my car at the impound the day before yesterday. All these things was in the car already. The gun, the pistol was in the trunk. They never checked the trunk because I was in a process of moving. So all my clothes was in the trunk. So they never went through the trunk. The bag that they didn't take, that they took this time for property, still had the pills and a little bag of marijuana inside there.
Mr. Stewart, this is being recorded. And before you have an opportunity to speak to a lawyer, don't say something that prosecution can
No,
get.
I'm not. This is facts. It's fact. The officer advised me to ask you, can I explain my situation to get the charges dropped so I can continue on with the case that's occurred now? Because it's the same charges. He called the officer and asked them everything about what happened, and they clarified it with the officer. He said it was nothing he can do about it because he was under oath. The only person that can do about it is the judge. I advise you to ask the judge to drop the charges so you could continue on with the charges that occur. He's the only person that can do that because I just got my car out of the impound.
Okay, stop. So I'm accepting everything that you're telling me as 100% true, but that's not how it works. If an officer believes that they made a mistake, they contact me and say, hey, Judge, I made a mistake. I need you to recall this warrant. I need you to dismiss this. I need you to do whatever. They don't tell you to come to me because everybody. No, listen to me, please. Again, I'm accepting everything that you're telling me as being 100% true, but
Yes,
that's
sir.
not how it works.
Yes, sir.
So if, what is it? Officer Hanks. If Officer Hanks contacts me and says, hey, Judge, look, we arrested this guy same time, both charges. We need you to dismiss this WAA. It'll get dismissed.
I mean, can't you see the charges that I just got arrested for and I just got out on the 18th, sir? It's the same charge.
It's not the same. It's similar, but not the same. October 15th. Hold on, sir. On October 15th, you were arrested on possession and use of drug-related objects, trafficking in cocaine, illegal drugs, or methamphetamine, possession of firearm and knife during the commission or attempt to commit certain crimes, purchase, possession, manufacture, distribution, or sale of marijuana, purchase, possession, or have control of any controlled substance in schedule 3, 4, or 5. Possession of cocaine. So that's 1, 2, 3, 4.
4 felons.
5, 6. 6 charges.
Yes, sir. But
I have 4 before me now.
Okay.
So do you see why I'm saying they're not the same?
But I'm telling you, it came from the same incident. It was all these drugs was in the car. I just got my car out the impound, sir. I just got the car out.
Mr. Stewart, you can get arrested for something one day, and then further evidence is developed later, and they can come back and get additional charges based upon the new evidence, even though all of that may have been present at the exact same time. You're not charged based upon catch me if you can. If hey, you didn't catch it the first time, so that means I'm clear.
Oh, it's my fault that they didn't get all the drugs out. I just got
Mr. Stewart, can you repeat back to me how I told you this can get resolved?
You said I can be charged twice, even though the charges didn't apply the first time. I still can come back and get the same charges, even though I'm explaining to you my situation or what happened.
That is not what I said.
That is not what I said.
So, Mr. Stewart, if Officer Hanks would like to contact me and have these additional charges removed, then I will do that. But sir, the document that I have before me says that these charges were placed on you yesterday.
Right. From the incident, I got charged on the 18th. I know they was placed on me yesterday. I just got my car out the impound, sir. The drugs was already in there from the first time they checked the vehicle, sir.
Okay, Mr. Stewart, we're gonna move forward. Okay. Are you gonna hire your own lawyer?
Yes.
I got it.
Okay. Now, Mr. Stewart, again, I'm accepting what you're saying. I had all these drugs in my car and they didn't get all of the drugs when they arrested me the first time. They found out later I had more drugs in my car. So then they charged me with additional drugs. But Judge, they didn't do it the first time. So how they gonna charge me the second time?
Right. They didn't get all
I explained that to you. Now,
so it's my fault. That's my fault.
It's your fault for having all them drugs in your car. Yes, it is. It is.
He's literally saying it's their fault that they didn't take all the drugs the first time. So so now, because they're in the drug, they didn't take the first time. So why should I get these new charges? I cannot believe this is his argument. I cannot believe it.
Get the car out the impound and check the car for more drugs if I thought they got all the drugs, sir. I just got my apartment.
I don't know. I don't sell drugs, so I don't know. I don't know. Okay? I don't know. Maybe
so you really gonna deny my bond?
I sure am.
All right.
Have a good day. Mr. Story.
Oh, that was fantastic. Let's get rolling. Let's go. Something else. All right. And I love Judge DeSanto from Wyandotte. I always got her. This one's must be the punch. Had to be the punch.
And you understand that you have the right to have a contested hearing in this matter. By entering into a plea, you will not have that contested hearing.
I understand.
And you also understand that by entering, that the recommendation is for you to continue and complete all terms of probation at a $50 probation violation fee and 30
Yes,
days
ma'am.
on the alcohol tether. 30 days on the alcohol tether, and there would be mandatory jail for any future violation. You understand that that's the recommendation?
Yes.
Santo bomb.
And knowing all that, you still want to continue with your plea.
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
All right, and sir,
Yes, ma'am.
you are currently on probation with this court for disorderly conduct, correct?
Yes, ma'am.
And one of the conditions is for you not to possess or consume any alcohol or drugs that are not prescribed, correct?
Correct.
And what is it you had to drink prior to your test on January 17th?
It was like a punch. It was like I went out with some friends. It was like a punch. So I'm not sure what they mixed in it. It was just like a punch.
Look at the guy in the bottom left looking at him.
Where were you at when you went out and drank this punch?
Just like some new friends I had met. So I don't really know them well.
Were you at a house or were you out somewhere?
At a house. At someone's house.
So did you ask what was in the punch before you drank it, sir?
No, I did not.
Well, did these individuals know that you're not allowed to consume any alcohol?
No, they were unaware. No, I did
So
not.
that's your responsibility to make sure what is contained in something that you are consuming.
Correct.
So how much punch did you drink?
Probably like 2 or 3 cups.
So you didn't taste the alcohol in the first 2 cups?
It didn't taste like alcohol to me. No.
Okay, so, all right, well, the court does find that the plea is knowing, voluntary, and factually accurate. The court will accept your plea.
We remember, the one that was floating around, the one that I posted before anybody, was the one, must have been the darn creamer. This was in DeSanto's, the lady that drank the creamer, the one that made its rounds. That was the same thing. So now DeSanto's dealing with creamer and punch.
To the
I don't know what
probation
they're doing in
violation, we
Wyandotte.
take this technical violation number 2. And sir, is there anything you'd like to say regarding the recommendation?
No, but I do have something to say.
Okay, what's that?
I did learn a lot in the alcohol awareness program with Michael. I have completed it, and I'm actually going to be on his Zoom again. He's off for February. He'll be back in March because I did actually learn a lot from him. And I have enrolled in mental health awareness, and so I'm getting help with that every Monday for the next, well, I say every Monday for all February. And I want to say March 5th that I will be seeing mental specialists and doctors as far as my mental health and physical health and therapy for
for all February. Every Monday in February, I'll be seeing a therapist or a doctor as far as drinking and my mental health. I actually have an appointment today. I'm still working 6 days a week, 7 hours a day. So my schedule is very tight, and I'm still doing dropping every time they ask me to drop. So I'm just basically completing. I'm complete with everything that the court ordered me to do, and I'm just letting you know that I am seeing a mental specialist, and it's based on alcohol, like to get you off alcohol. Like I don't feel like I have a problem, but is to help you get off alcohol, to mental health, help you with housing. I don't drive. I never drove in my life. I don't possess a license. I ride a bike. So when the police picked me up, I was on my bike. So I'm just letting you know as far as what I'm going through. And I talk to my probation officer if not every other day. I send her all my information as far as doctors, as far as appointments, as far as everything that she asked me to do. I have completed everything that the course has asked me to do. I have completed. And I have learned a lot through this process as far as drinking and as far as mental health. So I am appreciative of going to the specialist and talking to Dr. Michael. I don't know if he's a doctor, but Mr. Michael, who do the Zoom as far as the alcohol and awareness program, he's very great. And I have learned a lot from him. So I just wanted to say that.
All right, well, thank you. I'm very glad to hear that, sir. And it's good to hear feedback regarding that program. And I'm glad that you also are taking the steps to continue with that as well. So here's what I'm going to do. The court's going to adopt the recommendation. All right. So
yes, ma'am.
Probation's going to continue. Your conditions are going to continue. And the court's going to indicate a $50 probation violation fee, 30 days on the alcohol tether, and any in jail for any future violation. Okay. So you've been on probation since October, and this is now your second violation, and you also had a bond violation. So
a bond violation? What is the bond violation about?
No, that already happened. That was back in November. I'm just making a note as far as since you've been on probation. So
okay.
So make sure that you are, when you're consuming anything to drink, it's your responsibility, sir, to find out
what's in it.
Because yep, if there's another violation, the individuals that put the punch together aren't the ones that are going to be in the jail. That'll be you.
Right.
Okay. Right. All right. So the court's going to adopt the recommendation. So I'm going to have you email back into Ms. Shaw so she can get you set up with the alcohol tether information. Okay.
Yes, ma'am.
Heather, I'm on, baby.
All right. Thank you. Anything else, sir?
No.
All right, we got some newbies coming in, so I know no one's seen this before. So I'm gonna replay this because it's hysterical for the newbies in the room. This is hysterical. You ready? Here we go.
16 to 20 over. What would you like
because I know everyone in the room wants to see it again.
I would like to go with the first one, the one that says impeding no points.
Okay, so
I admit to the
speeding. Okay, so on SP 1421245, January 9th, 2023, ma'am, were you driving a 2009 Saturn in the city of Detroit?
Graduate.
Yes, sir.
You were pulled over by a Detroit police officer some point that day, ma'am?
Yes, sir.
And prior to being pulled over, you were speeding 16 to 20 over the posted speed.
Yes, sir.
Thank you. The court satisfied will amend that to impeding traffic. That's a no point offense, and that fines and costs carry $175. How much time do you need to pay those fines and costs, ma'am?
I can have it next week.
I'll give you 30 days. That sounds like enough time. Just pay it sometime in the next 30 days, okay?
Thank you so much, Your Honor. I really appreciate that today.
Yes, ma'am, you're welcome, absolutely. Do you have any questions?
No, only question I have is, will I receive something in the mail via email?
Are you on the Promenade Street address still?
No, I'm at 232.
Wait, Miss Karen, you're live on YouTube to the world, so I don't want to give out your full address unless you want to. If not, I can do a number to.
I'm on Beechwood.
Okay, so that's not the address we have. So take down this phone number, Miss Karen. As soon as we finish, you can call right into my courtroom, and Miss Tate will answer the phone and she'll update your address in our system, and we'll send you out paperwork to wherever address you tell us, okay?
Okay, what's the number?
It's 313-965-8774.
Thank you, Your Honor.
All right, here we
You're
go.
welcome. Anything else, ma'am?
Let's get
No,
serious
sir.
for a
It's,
second.
thank you, officer.
All right.
You're quite welcome.
Nobody told.
egregious
All right, so this one, it's a Judge Mistaken from Grays Harbor, West Coast. I think it's Washington State, and he is shocked at the recommendations. After listen to what is going on here. Listen very carefully, and you decide and tell me what you feel in the comments. If the judge did the right thing, I think he did the right thing. You have to consider the defendant's mental state of mind, but also what has happened.
Context of what was being said to the minors, but he has no criminal history. This a plea agreement will allow him to get the help that hope.
-14.
Okay, here we go.
On for sentencing.
Sorry about that.
I'll let the parties know that the court did receive and review statement of prosecuting attorney as well as the defense statement, as well as the attachment of the pre-sentence investigation report and the other attachment from the defense regarding his prior evaluation. All right, so court's fully briefed. Let's proceed. Sentencing.
Your Honor, I am going to rely on my sentencing memo. I think it covers most of it. This was a pretty egregious in context of what was being said to the minors, but he has no criminal history. This a plea agreement will allow him to get the help that hopefully he needs so this never occurs again. But so we are asking for the bottom of the range.
All right.
Thank you, Your Honor. It's Dennis Segan on behalf of Mr. Osley, who's present to my left. We submitted materials with the request that the court would follow the recommendations by the state, which have been pleaded to by Mr. Osley. Other than going into more details with the evaluations stated, Mr. Osley's been dealing with what I'll call a sexual addiction for about 10 years. And unfortunately, we weren't able to catch it until now, but it's caught. We got him and we understand where we are. Mr. Osley is completely remorseful and understands the, lack of better words, bad choices that he has made with the use of communication device. He's been working on a statement for about a month, which I have reviewed with him that he's would like to pronounce to the court. But specifically, Your Honor, would request that the findings be recommended, and he's really looking forward or wants to engage in the sexual offender treatment program, which was recommended by the PSI and is a condition of his community release that will be in the Appendix H, I believe.
All right, Mr. Osley, you have the right to make a statement before I impose sentence if you wish.
All right.
Listen to this.
I'm sorry for any wrongdoing with my Snapchat account. By the time I realized the age of the people I was sending pics to, they were sending me pics from the start. From this, it was too late to stop or unsend the photos. I did ask them to stop and they did not, and they asked me for them as well. And with me having ADHD, autism, Asperger's syndrome and a learning disability as well. They took full advantage of that as well, right? I should have caught on from the start, yes, but I did not in time. So I'm very sorry for any wrongdoing. And due to this, I don't plan on going on Facebook, Instagram, Snapchat, or any type of social media ever again. After this issue. And for the record.
For this reason.
And for this reason, I'm not from Grace Harbor at all, period. I live with my mom and dad in Yakima, Washington, and take meds as it is for all my medical issues. Mental issues. Thank you for giving me the time to explain it better to the courts.
I don't like this. I don't like it at all.
Good,
I'll
Judge.
tell you why. 2 reasons. First of all, there were multiple victims. So I can't understand a bottom end recommendation. That's number one. There's no doubt from the reading of reports that he was communicating with multiple underage and receiving pictures of multiple underage girls. Just because he only got caught and they only had evidence for one doesn't mean the other ones don't exist. That's number one. Number two is, just like the DOC report seems to indicate in their interview of the defendant, and now he just confirmed it in court, there's a complete lack of remorse and understanding. You can't say you're remorseful and then blame the victims. Really, the 10-year-old girls that you were asking for nude pictures from, it was their fault? That's a non-starter for me. Top of the range, 29 months. Thank you.
Bang! 29 months, gave him the top. Prosecutor recommended the bottom.
Fill out the judgment and sentence, sign and fingerprint. Thank you.
All right, 29.
Yes, mandatory legals, community custody, sexual deviancy evaluation, follow-up, etc. It's 36, isn't it? Ms. Zorn, is it? Community custody is 36, right?
Yes.
Yeah, 36 months. Thank you.
Bam.
And I marked him
Bang.
indigent.
Yes.
Thank you.
Indeed.
Doesn't matter.
Thank you.
And I've also done a anti-harassment order, no contact order for the victim in this case.
Yes, and also too, in case it's not in the conditions, the appendix on DOC, there's no, on this one, it's crime related. There is no internet. There's no internet. There's no social media for this gentleman, as long as he's on community custody. No access to internet, no use of internet due to the nature of these offenses. Thank you very much.
All right, here we go. Now Middleton locked somebody up, so I'll close with Middleton. I'm going to get another one too, guys. Here you go. So let's get a little Middleton going on here.
Magically appeared.
Usually magically appear when I get a notice to appear, but
Your clients were both here early. This is the day they start working on my courtroom.
oh,
And then we're gonna, the whole day was blocked out, the whole week is blocked out, but I asked if I could use the morning.
sure.
And so I set some of the sentences here for this morning. And I appreciate you being here. This isn't a normal criminal sentence time, 9 o'clock on a Monday morning. But we've got some time to use and we're gonna use it. Mr. Trine was here early. And I appreciate that. I don't know if the prosecutor's gonna be here. I think they're short-handed.
In jail, I ain't supposed to be in this jail, bro.
I didn't mean to do that. I swear. I didn't mean to do that.
2451. People versus James Phineas Trine III. This matter was reduced at pre-exam conference by Chief Assistant Prosecuting Attorney Joshua Robert. He was originally charged with felony resisting and obstructing and domestic violence. The defendant entered a plea to 2 misdemeanors of domestic violence and attempted resisting and obstructing a police officer. The matter was set for sentencing today because I wanted to get victim input and the police report. I don't think we have any victim here today. We did get the report, and I'm ready to proceed. Mr. Knopfinger, what would you like me to know?
Just a couple things, Judge. So what I would note here too, honestly, I don't remember if it's in the report or not, but I reviewed the dash cam, which does a good job of capturing and everything. So victim is interviewed, 911 call from an anonymous, well, not so anonymous, but I'll leave it anonymous at this point. And then they interview the victim. She does say, look, I'm just trying to get my stuff. They were involved in a breakup. Some of her stuff was still there. I think things got kind of nasty there with the breakup. They're no longer in that relationship. She was coming to pick her up her stuff. She did state to the officer, I don't want him to go to jail, meaning Mr. Trine. The dash cam, the way that the police car is parked, and I mean, you're able to capture, it was able to capture the cops going up. Mr. Trine is in the house. His child is in the house. The officer goes up, knocks on the door. Mr. Trine is, I think, still a little frustrated, and understandably so. He says, get off my property. The officer then says, well, you need to turn around. Mr. Trine then goes back in the house. The officer kicks down the door. There's some words exchanged then after that. So that was the basis for the attempted resisting, obstructing. He did have his door kicked down. He did, in fact, go to jail that night. He was arraigned the next day. So he's entitled to 2 days credit. He took responsibility before the court. A couple things about Mr. Trine is he is on SSI, full disability. He has been for nearly 2 years now. CPS didn't get involved, didn't remove his child, which is good. He did have relatives come take care of the child. What I asked the court to do today, he hasn't had any contact with the victim. There's an input. So really all we have from the victim is that statement when she was initially interviewed, and she said, I don't want Mr. Trine to go to jail. So I asked the court to consider all of that in sentencing Mr. Trine.
See if the prosecutor has sent anything. Mr. Trine, what would you like me to know?
That's pretty much it. I mean,
Could you speak
he
up?
covered it all. He covered it all.
Here's Deborah. Good morning. I know you've been having to be several places at once.
Yes.
Surprise, surprise!
And as I mentioned, this isn't a normal time for criminal sentences, but the court was closed all week for the construction. But the guys aren't going to be here till noon. So I put all these 5 sentences in here to utilize this little block of time. So
Every minute counts.
yes, it does. There is an open warrant for the complaining witness. She's got some issues of her own, and so I'll just leave it at that. There's an open warrant for her, and I don't know where she is. I had some cases with her late in the year last year. I've known her since she was a little girl, and Mr. Trine, I've known you since you were not that old either. I mean, you're teens. As Luke indicated, the R&O wasn't the worst. Mr. Trine does have some baggage. He has an MDOP, and DV was dismissed in 2019. He never did pay the restitution that was ordered in that case. In 2004, he had an assault and battery that was reduced to disturbing the peace. 2007, he had assault and battery that was reduced to disturbing the peace. And a felony charge. 2008, he had an MDOP and disturbing the peace. So he's got 3 disturbing the pieces and DV where he's ordered to pay restitution in a MDOP case that he never paid the restitution. But I think the case is closed. Ms. Hutchinson, as indicated, did have some issues of her own. And as Luke said, she didn't really want charges so much, but she did have what appeared to be assault marks on her neck. And James was all agitated and not very respectful of the police. Deborah, what's your thought here?
And we haven't had any contact from the complaining witness, so that makes it difficult. Frustrating that there was potential strangulation involved, but not the cooperation from the witness. You know, when the police give a lawful command and somebody runs into their home and resists, it's very concerning for law enforcement. They don't know if the person is going to get a weapon or if they're just being belligerent, trying to get away from them. It creates a very dangerous situation. So I'd ask the court to take that into consideration in deciding what to do, Mr. Trine, today.
In the 2019 case, it started out as a domestic violence and malicious destruction of property less than $200. You failed to appear. I gave you 6 days credit, 6 days on the MDOP, and the complainant in that case was Amanda Hutchinson. I got her $325 or 5 days in jail due by November 15th of 2019. Put you on a payment plan and you didn't pay, and you did a bench warrant. You did 1 day, you paid $50, paid $100. I think you still owe $250 in that case. It's the same complaining witness and another DV.
Is he gonna drop the hammer or what? What do you think? Will Middleton drop the hammer?
So after chasing you around, you never did pay it, so I'm gonna wipe that out. Four days jail credit, 0, leaving 4 days to serve. That will wipe out the fine and cost and restitution in that old case. Attempted resisting obstructing, I'm gonna give you 5 days jail credit 1, leaving 4 days to serve, which will be served at the same time. As Debbie says, this could be dangerous in this day and age. Firearms are all over the place. When people run back into the house, they don't know what they're dealing with. But I'm getting 5 days credit one, leaving 4 days to serve, consecutive with DB and the old unpaid fine and cost case 195.
So you're gonna just say consecutive or concurrent?
Concurrent, I'm sorry, thank you, Deputy. Basically, you're going to jail for 4 days for not paying your old fines. And I'm just gonna wrap these into the same time frame. Not that you don't deserve a little bit of jail time here. As I indicated, there were 4 previous domestic violences reduced to a misdemeanor, disturbing the peace or something less.
I didn't think he was going to do it.
This was the same complainant. She's struggling with drug issues of her own, and there's a warrant for her arrest. The fine in that case is none.
He's going to do it. Yeah, that's a lot for Middleton, though.
$5 days credit one, leaving 4 days to serve. 0 fine, but there's a $75 crime victims' rights fee, $50 state minimum fee, and a $150 attorney fee, which is $275. I'm gonna give you time to pay it, although you didn't pay the last one. I want you to pay this one. I'm gonna make it due by May 1st. I didn't order any probation. I didn't order domestic violence treatment. Didn't order anything else. Just a short jail sentence, which wipes out your old fine. All right, you're gonna go with the court officer. You're gonna do 4 days in jail. You won't give you 1 day of good time. Otherwise, you're good to go. In 2 judgments.
Definitely. Agreed. Agreed, deadlift. Agreed. Cuff him. All right, so let's do a little request time. It's my first live. I'm still going. We got what, almost 160 in the chat. This is fantastic. I can't go. I can't leave. I can't leave. I can't leave. Let's see. Let's bring someone back. Any requests in the chat? See if I got it. See if I got an oldie but goodie. Nobody does live requests, do they? Huh? Let's see. Let's see. Let's see what I can pull out. Let's see. Tommy, that's tomorrow. I got that from my recording. Marilyn!
You brought in.
All right, let's do it.
Still having a concern. Attorney out of the office, I'm of course not right now. Okay, who are you hiring? I have.
All right, here we go.
Concern. Attorney out of the office, I'm of course not right now. Okay, who are you hiring? I have a couple I'm talking to. Have you? When they come, I'll sign them to the docket. Okay. They'll sign them to the docket. But can you tell me who it is that you've spoken to? No, sir. Do you not know their names or?
Thank you,
I can't
Marilyn.
remember
Thank
my
you,
original.
Oakland. Much appreciated.
All right, so last time, I didn't even get to come into court. Y'all didn't even let me come into the courtroom. And then y'all.
Manning
sent
Webster.
back to
All right,
myself
I'll find.
to
I'll do it right now.
come,
Manning. All right.
Come to court today after I bonded out. Last time I walked in the court with him, we were supposed to be talking to the
Ooh,
specialist.
Ron Hell.
And then I walked in, we're doing a docket call.
I got
instead
a
of
ton
talking
of
to a
clips,
specialist.
guys. This is Mr. Peepee.
And I don't know, are we at a docket call right now? What are we doing today?
We were at a couple things. We were at a docket call and then a status on the report for the doctor that you met with.
Right. Well, he's a head shrink. I don't need a head shrink.
I understand.
I'm not crazy.
I know, but that's.
I know you need it for court.
I do need it for court. That's
I need
exactly
a
right.
specialist to evaluate the surveillance, and they lost the phone that was supposed to be introduced into the case.
I know, and Mr. Smith.
Like a little sloppier than I wanted to do, so I want you to get in and reorganize everything. Okay.
And Mr. Schmidt has brought all that up to the court.
Thank you.
And yes, I'd ordered the psychiatrist to interview you to give me a report, and that report has come back. The problem that I'm hearing though is that you and Mr. Schmidt can't, y'all don't have that attorney-client relationship anymore that's healthy to the point where you can communicate to Mr. Schmidt, where he can communicate to you, and that y'all can get on the same page with how to defend your case. So that's what I'm hearing is the concern for you and Mr. Schmidt as an attorney and officer of the court has brought it to my attention that you don't want him anymore. And so he's asking the court to allow him to withdraw as your attorney. And my only question is once I allow Mr. Schmidt to withdraw, then you don't have an attorney. And that concerns me because now you're by yourself and we're supposed to be moving forward with your case and you won't have an attorney representing you. That's why I'm asking, who is it that you're talking to so that I know that you're being represented?
Do you want me to look on my phone?
Do you on your phone, do you have the
My
names?
phone's outside.
No, that's okay. That's okay. So you're telling me that if I allow Mr. Schmidt to withdraw, that you're going to hire an attorney?
Yes, sir.
Okay. All right, Mr. Schmidt, then I will reconsider at
All
this
right,
time
let's get
your
him,
motion
Manning.
to withdraw as counsel, and the court will grant your motion to withdraw, and you are removed from Mr. Gerard's case at his request.
Thank you.
And I'm doing that, and I'm not appointing counsel for Mr. Gerard at this time. He's been found to be indigent at this time. However, at his request to hire an attorney, I'm not going to appoint you an attorney at this time. I'm instead going to reset your case and give you time to hire your attorney. All right. So we're going to reset the docket call to March 7th. So that's 30 days.
30 days.
That's 30 days. Okay.
And on the reset, we're coming back for a docket call?
We're coming back for a docket call and competency evaluation, all of that. Status on that.
Okay.
But everything that we were set for today, we'll discuss again on the 7th.
All right.
All right. Now there's one other, Mr. Schmidt, that's all. You're excused. The only other issue I have, Mr. Gerard, is that I asked pre-trial release, I asked Mr. Waddell to get a UA sample from you
You
today.
got a UA from me, all right.
And he told me that it was not sufficient, so I'm gonna need you.
No, I just went up there and passed the UA.
I understand. He's reported.
So,
Listen,
I bonded out a $10,000 bond.
I understand.
All
right.
Or a PR bond. I don't get that.
You're not on PR bond.
Oh,
You
man,
posted
huh?
a surety bond. And part of your conditions of being on a surety bond is that you're gonna be subjected to your analysis exams anytime that I say.
And I just took your analysis exam and passed.
I understand. He says that it's insufficient.
I don't know how to say sufficient. I just went up there and took
It
your
does,
analysis and passed.
it doesn't matter what you think. It
Matter of
matters.
fact, I have an EEG board on my head and I'm gonna send you the video of me passing that UA.
Okay, that's fine. But I'm gonna want you to give another one. Okay? If you pass the first one, you'll pass the second one. Okay?
I will send my lawyer up here to see you because I did pass that UA.
Well, your lawyer's supposed to
I
be
took
coming to
that.
see me anyway. 'Cause
Yes,
that's part of the
we
deal.
have lawsuits issue because my state is ruined.
Here we go.
Well, he said, y'all said there was different officers.
I saw different officers, but when I'm saying you're perfect, investigative falls, I all cases.
What, do you want to call that officer back?
I can see,
Yeah, I mean, he didn't act like, he said it was his only case.
she said it was.
KT, that's in one of my, it's in one of my older videos.
But specifically, what
Remember
we
this,
take
Ms. Lilly
exception
and
to,
Ms.
Your Honor,
Hood
is
are
that
arguing?
in paragraph 1 in the order, it says, as such, the court finds that after the hearing, the evidence and argument of counsel, there's no immediate risk of harm to the petitioner. We don't specifically take exception to that because in the court's ruling on September 30th, the court did indicate that there was no significant risk of harm in reference to the petitioner. What we take exception to, Your Honor, is that in the order in paragraph 1, it stated that furthermore, the court finds the petitioner did not provide sufficient evidence to support her claims of physical violence by respondent. If the court can look at the transcript that was provided on September 30th of what was taken down, the court did not say that the evidence was unsupported. What the court indicated in its ruling is that on page 5 of the transcript that's attached as exhibit A, line 4, the court said the burden here is the preponderance of the evidence, more likely than not, which is a higher burden. You have probable cause. So I didn't see a whole bunch of proof of anything with the bruising on the neck. She shows us a bruise on her leg, no bruising of the neck. If she were choked, it would use the broomstick to choke her, that there was none of that. I mean, I didn't see but one picture of the bruise on the leg. As Your Honor may recall, the petitioner didn't necessarily just allege that she was choked. She also alleged that she was hit with the broomstick too. So in reference to the petitioner saying that there was not provide sufficient evidence, that's not what the court's ruling was. In addition to that, the the respondent indicated that although petitioner claimed the respondent choked her with broom, she failed to provide any evidence of the same. But as Your Honor, we can recall there was evidence from the officer who also indicated that he saw some bruising on her leg and also indicated that he was the one who took the picture. In addition, in the paragraph of the order, it specifically says the court did see a photo with a red mark on petitioner's bottom. However, her testimony along with the same did not appear to be credible. On page 5, the court did not make any mention about that she didn't seem credible. As I previously indicated, the court just mainly said that there was one picture of the bruise on the leg, and the court went on in reference to bond conditions that were pending. The court went on indicating to see whether Judge Morrison had an updated status in reference to that. The court went on in reference to, there was no mention in reference to my client found, excuse me. And again, Your Honor, we take exception to that because in the court's ruling, that or amend or set aside the final order and otherwise.
Instead, it's all testimony and evidence that was provided throughout the hearing, as is the current statement of facts. I can specifically point out several pages where the court themselves actually stated and made mention to the issues that are currently set out in the final ruling. For example, page 69, Ms. Sullivan is asked several times to leave her camera on. It also occurred throughout the entire transcript. Page 70, she was told that she was refused to answer the question. She needs to turn her camera on. She needs to turn the camera to look at her face. Page 87, the court made mention that she is looking at something and referencing something in reference to her testimony and what she's saying to this court. Not to mention, Judge, if you recall, you already made the decision. We're here on something where you already made a decision on. I provided my written ruling to the court through email, to which then Ms. Hood.
Okay. All right, guys. I'm going to cut it. I tried to get memberships, but I talked to Google support, and they said, well, you've been on for a couple months. And I said, no, I started my channel January 31st. And he said, you're not supposed to grow this quick. Your memberships aren't set up yet. So I guess that's a pretty good thing. So I am going live tomorrow night. I'm going live every night as much as I can. I appreciate it. I love you all. I thank you very much. And I appreciate every comment, everything. And I try to get better every single day. Peace out, guys. Let's roll, nerds. Have a good night.